We now have a special address on the importance of being, in financial sectors, a legal perspective to governance by Mr. Kaushik Mukherjee, President Legal India Bulls Housing Finance Limited. Mr. Mukherjee is a corporate lawyer with diverse experience across practice areas including structured finance, mergers and acquisitions, capital markets, real estate project financing, restructuring, and corporate and securities advisory. In the past, he has advised on transactions involving Indian, English, Russian, Kazakh, Ukrainian, Georgian, Irish, Dutch, Chinese, and Nigerian corporates, amongst others. Ladies and gentlemen, please give a huge round of applause to Mr. Kaushik Mukherjee, President Legal India Bulls Housing Finance Limited. Mr. Mukherjee, if you could please join us on stage. Thank you. Can we have a round of applause, please? We've just re-energized ourselves with a sumptuous lunch, so over to you, Mr. Mukherjee. Thank you.
So, hi everyone. Thank you for having me here. Of course, the first session after lunch is always a challenge. So I'll try and make this as lively as possible. Of course, at this time of the day, it's usually a difficult task, but I'll try my best. So what I'm going to speak about today is generally, a topic that is very important across sectors, which is quite important across sectors, particularly the financial services sector. Why is it important? Because corporate governance actually sets out the broad guidelines within which every organization has to stay, especially, listed companies, companies in financial services, highly regulated companies. It is basically the four corners within which every company and in turn every financial services company should actually conduct itself. Is it substantive law? Some parts of it is. But mostly it is the rules and regulations in relation to each activity that a corporate actually undertakes and the four corners within which it can operate. So let's just try and understand a little more. So the first definition of corporate governance actually comes from the OECD. So the OECD has defined corporate governance as a set of relationships between a company's management, its board, shareholders, and other stakeholders. So just to try and understand, what exactly are we talking about here? We are talking about a company, how it is going to be run. So who are the people who are involved in the running of this company? First is the guys who own the company or the shareholders. In the shareholders also, there is a wide diversification. So on the one hand, you have the guys who control the majority, or in other words, the largest shareholder or groups of shareholders who are actually running the company. So whatever profit that a company actually makes is ultimately the biggest beneficiary of them is the shareholders who are actually controlling the company. So these stakeholders are, number one, the majority shareholders. These could be, promoter, or it could be, basically. So promoter is the guy who generally technically controls the company. But now we have seen various companies in financial services where there is no identifiable promoter. But that is another topic for another discussion. But basically the promoter and the majority shareholders on the one side, the management that is actually running the company, i.e. its board of directors, KMPs, the key management personnel, and basically the other employees. So employees is another basket here. Majority shareholders is another basket. The lending institutions, or the institutions that are actually financing the operations of the company, is a third, the lenders. The fourth, and very importantly, are the minority shareholders. These could be institutional shareholders, basically investing in the company for gain and from a financial perspective, not strategic investors. And this very important subcategory also includes the public at large, because a lot of these companies are listed on the exchanges, they are publicly traded. So therefore, another very important stakeholder in the company is the public at large. Now, the real question is, whose interest is it that I am to serve? Let's go on. Corporate governance also provides the structure through which the objectives of the company are set and the means of attaining those objectives and monitoring performance are determined. So basically, corporate governance, like I said, it's not substantive. It is not asking you to do or not do something. That is also there. I mean, it is asking you to do or not do something, but it is setting out the boundaries within which a responsible corporate organization can function. Okay, so good corporate governance should provide proper incentives for the board and management to pursue objectives that are in the interests of the companies and the shareholders, and should facilitate effective monitoring, thereby encouraging firms to use resources more efficiently. Now, let us just try and understand this. The biggest question that I come to you here with today is the board and the interest of the shareholders. And here again, I'll split it up into those two major components. One is the majority shareholder and the other is, of course, the minorities. Who is the one whose interests are to be served here? Because a lot of times we see, in a promoter-driven setup, the interests of the promoters may be short run, the interest of the board may be longer run, with a longer run perspective. So whose interests are we trying to serve here? Good governance at the very outset, before, we will go into detail with some of these aspects, but good governance is generally a balancing act. You cannot see any one person's interest in isolation. The interests of all of these stakeholders in a harmonious, and albeit sometimes it is in a disharmonious manner, met, but basically the interests of the company in the long run is something that cannot be ignored under any circumstance. Now, let's basically move on to the approaches of corporate governance as we've historically seen. So, of course, the first approach that everybody went with was that companies are here not for love and fresh air. They are here to make money. So what is the aim of every company? It is to maximize profits. Or is it? I don't know. I mean, that's something that we would intend to answer by the end of this presentation. But basically, is profit maximization the goal? Historically, that's what managers, that's what management gurus have said, that profit maximization is the goal. But today, in this day and age, we find that profit maximization, being the sole end, cannot be the goal. Because profit maximization entails a risk appetite. It entails, basically going into areas that are gray. It may entail. I'm not saying that it shall. I'm saying that it may entail. Now, in these circumstances, how will a good governed company act? They will certainly have to take a more responsible attitude towards corporate governance. In other words, the first theory, which is the theory of profit maximization, sort of says that traditional theory of profit maximization argue that only such an objective would ensure that the board strictly adheres to its duties towards the company and doesn't exercise untrammeled power. The board cannot be at liberty to do what it thinks best. It has to, so the traditional theory says that there has to be a profit maximization objective. However, as we have basically come through an evolutionary process across jurisdictions, and now in India, we find that acting irresponsibly without basically a broad framework of governance within which we are acting, which will enshrine concepts of transparency, of disclosure, of no market manipulation. All of these things are very important, and at the root of this is responsibility. Responsibility towards the society in which the company functions, responsibility towards the employees of the company, responsibility towards the minority shareholders of the company, the public shareholders. So profit maximization in the short run may increase the immediate net worth, but in the longer run, it may not work to your benefit. So in South Africa, in the mining operations, it was seen that the unhealthy conditions gave rise to a mass epidemic of tuberculosis in the mining sector. Now, all that the mining company needed to do was cut back on the profits a little bit, responsibly spend that towards the betterment of the workers. And they did not do that, thereby leading to an epidemic in the short run. Now, clearly, is that how a responsible corporate should act? If it is taking resources from nature, then the least it can do is ensure that the people working there the conditions are fit for them to work, so that there is a responsibility towards society. So this slide basically talks about corporate governance and responsibility towards society. In the Indian case, there have been multiple instances. So we have CSR now as a compulsory spend by companies. A lot of companies are making this a spend which is not even compulsory, which is voluntary. Why? Because good governance also precludes that you return to society and not just take. So, in a donations case in the Supreme Court in the US, now what the Supreme Court says is that a donation to a university, this is on the same social sort of line, before we move to other more nuanced parts, but basically the social approach is that basically that a university results in a fillip to the number of college educated individuals, which in turn ultimately leads to a reservoir of scientific and executive talent that ultimately forges growth in industries. So the industry that is actually giving that grant to the university, maybe not receiving something directly from it, but it is actually benefiting the whole of society and that organization itself, because the more managers who are talented, the more trained and skilled the technical workers are, the more chances are of that company of continuing to make profits in the long run and not just in the short run. Now let's just quickly see the governance framework in India. So most importantly, and this is something that we've seen over the last 15-20 years, is the independence of the board. So what do we mean by independence of the board? Historically, India was run by family run. Most of the businesses in India were family run. The directors used to be people nominated by these persons running the company or the majority shareholder in the company. This is what we've seen historically in India. However, that does not work for a period now. And of course, the independence of every board is highlighted today. So there has to be a set of independent directors that will either be half or 1/3 of the board of directors, depending on whether the chairman is executive or non-executive independent. Then is the committees. So today there is in every listed Indian company has to have, and certain other regulated companies in the financial services space have to have a audits committee and a remuneration committee. None of the decisions in relation to financial transactions are taken today without a sign off by the audit committee, which is in turn responsible. Because recently there has been an amendment and actually the liability of independent directors have been brought out. So every independent director has a liability under statute in relation to governance. So independence of the board is extremely important, and so are the committees which are the majority of whom are run by independent directors. So today the majority does not any longer, and for a while now, have the power to have untrammeled power, as we were seeing in the first slide. There is no untrammeled power anymore. Liability of independent directors, we just said that. Okay, now another very, very important point in corporate governance is related party transactions. So, related party transactions today are highly regulated in India. Not only is there disclosure in the financial statements in the manner, are we running out of time? Yeah. So basically disclosure has to be made in relation to all RPTs. The major RPTs need to go to the shareholders for their approval, and the ones that are not of a certain material threshold, you can do with a audit and a board resolution. But in any event, RPTs need to be authorized. So basically, other than that, these are some of the other, and I can make this presentation available through Elet here. But basically, these are some of the other key corporate governance features in India. Other than that, of course, we have the ICDR regulations that deal with disclosure in India in relation to all offerings, and there should be transparency and disclosure now, which is enshrined in these regulations. And lastly, before I go, I just want to mention what the US rule in relation to this is. So they have a simple anti-fraud. Instead of an elaborate corporate governance network, they have a simple rule called Rule 10b-5 of US securities laws. This is an anti-fraud rule. So basically, if there is any device, scheme or artifice in relation to a securities offering, if there is any untrue statement of material fact that has been disclosed by the company, of course, this is scienter-based. Unlike India, in India, actually, market manipulation law, you need not have intent. FUTP, there are many judgments that you don't really need intent. But in the US, actually, you need intent. So there has to be an intent to defraud. There has to be an intent to make an untrue statement. And there has to be an intent to practice in the ordinary course of business, which would result in a fraud or deceit. So basically, this is the US rule. There have been many case laws, many decisions in relation to this. I will end with one single case in the United States in relation to Rule 10b-5. So there was one, and how 10b-5 came into being. So basically, there was one very well known, in fact, I will not name the company, very well known footwear company that did a public issuance of securities. Just before the issuance of securities, what they did was they told all their suppliers that we will sell you, instead of taking X number of shoes that you do on a quarter, please take 3X the number of shoes, with the understanding that once the offering is over, you will return those 2X shoes to me as defective, and I will take it back. Revenue recognition happened on sale, thereby inflating the revenues of that company for that period. So what the court in the United States held is that the lawyers, the auditors, etc., who are doing diligence, especially the lawyers, doing diligence on the company, they should have asked the company the question that how in this quarter did the profit spike to this extent? And accordingly, it was held that there is a responsibility that we have in relation to these securities offering, and that is a duty of care for each and every person, duty of care for the lawyers in relation to the company, duty of care for the managers in relation to the company, and most importantly, a fiduciary duty of care by the directors and promoters of the company. Thank you.
Thank you so much. And if I may request Mr. Steve Hudgrave, CEO, co-founder, Varthana, to please join us on stage and present a small token of appreciation to Mr. Kaushik Mukherjee. Sir, please. Can we have the memento and the magazine on stage, please? Thank you. We would have loved to hear more from you, Mr. Mukherjee, but unfortunately we have a paucity of time here. So thank you so much for being here. Round of applause, please, for Mr. Kaushik Mukherjee. Sir.